resources in general for plaintiffs' attorneys. We have a dense session planned tonight, and it's chock full of meaty material, so I want to dive right in with little preamble. My name's Margie Smith. I'm a structured settlement broker with Millennium Settlements. It's a settlement company that works only with plaintiffs and their attorneys. Another topic for another time is why that loyalty to the plaintiff's bar has implications that are crucial for you and your clients. But at the moment, I'd just like to introduce two people who are also here with us and who manage cases in our company, Rosa Florentino and Sophia Nava in the back. I hesitated, sorry, because Sophia's new with us, just started and hit the ground running. Both Rosa and Sophia speak Spanish and translate documents, and they're paralegals, so please find them and ask how they can help. Would also like to take this moment to thank Thorsness Litigation Services for filming free of charge. I used to work at Thorsness, and Jim Drimmer and Eric Thorsness, the owners, are still my best friends in town. And where is Suzanne de la Fleur? Everybody knows Suzanne. She lights up a room like nobody else. And when you need deposition services or in-trial tech support, which Eric Thorsness does, he's sitting right there, make sure you call them. And thank you all so much for covering the filming charge. And Colette Stark, who's sitting right there, she's doing the filming. And I know Colette from my Thorsness days, because I'd come get in your way when you were setting up depots, and I'd come try to hobnob with people. But the clients loved Colette, and the quality of her work's superb. I'm going to have free DVDs of this information, because it's rare to have these kind of speakers together all at once. And so if you want the information later, just let me know, and I'll drop it off at your firm. Speaking of the speakers, I'm not going to belabor the point, because you all are probably here after having read their biographies, and in your packets that are back there on that table, there's detailed information about each speaker's credentials, but I hope it'll suffice to say that Rob Wood of Wood LPP in San Francisco, John McCullough, who is Vice President of Advanced Marketing for Integrated Financial Settlements, which is a structured settlement company that does the most business in the country. It's actually the holding company of Millennium, president of which is right there, Kyle Bowman, for whom I work. But back to John, he is Vice President of their Advanced Marketing, and then Ken Stern of Ken Stern and Associates. These three guys are the go-to and nationally renowned experts in their respective fields of taxation and of financial planning. So thanks for being here to offer your time and knowledge freely. We'll take advantage of having you here. I developed this MCLE because I wanted to address the most burning tax and financial planning issues that face plaintiffs' attorneys who do contingency work. Those of you who do that kind of work bear a multitude of responsibilities and face unique pressures, and all of that makes for rewarding work, I know, but also stressful and consuming work. So I hope that we can shed at least, or that you guys can shed at least a little bit of light on some of the questions that may plague you. Ask questions as you go, please. And we'll just dive right in then. We'll start first with topics that impact plaintiffs directly, and we'll talk about taxation of legal recoveries. John and Rob, I'll start with you, please. Would you all please speak to personal injury and wrongful death recoveries? Those are what we call qualified cases, recoveries on which they're tax-free, and if those clients end up structuring any or all of those recoveries, they're structured on a tax-free basis, but there are factors that can trigger taxation on those PI and wrongful death recoveries. Could you all speak to that, please, and also address how molestation cases or any case of a sexual nature is not necessarily considered personal injury, physical injury or personal injury? I'll just let you go with that. Thank you.
I did the first one.
Okay, thanks. Hi, everybody. I'm Rob Wood. I'm a tax lawyer. Somebody has to be a tax lawyer. Everyone has to pay taxes. I was joking with John McCullough here that I was going to announce the Internal Revenue Code has been repealed. That would be a test to see whether all of you are paying attention. It has not been repealed. It is with us. Margie mentioned Section 104 of the code, or the personal injury exclusion. That is Section 104. It's been in the tax code for about 80 years. It's been there forever, and it's the rule that says that your clients, if they're injured in a car accident or something like that, they don't pay tax. I think all of you know that. Hopefully you also know that the rule was changed in a couple of different ways in 1996, so it's been a while. In 96, the law was changed to say the recovery had to be for a physical injury or physical sickness. The word physical wasn't in there before. It is starting in 96. I talk to lawyers even today that don't know that, so if that's news to you, you're not alone, but it is an important rule. Physical means physical. As Margie suggested, there are lots of lines drawn. What isn't, first of all, what isn't physical? It's very clear that if you have interest or punitive damages, those are two things that are not tax-free ever. And the only ways around that are in settlements. Sometimes there are ways of sort of recharacterizing things when you're, like any other context, when you're settling a bundle of rights. It may be that you can weight things differently or even ignore some things depending on the case. But if you have a check that's payable for $100 for getting your arm broken and another check for $20 for interest on getting your arm broken, or punitive damages on getting your arm broken, it's clear that the interest and the punitive components are taxable. If you think about cases where you have a judgment or a case settling on appeal or a judgment paid, you obviously have less flexibility. So, and that can impact the tax treatment of the attorney's fees as well. I guess let me say a couple of things about resources. So if you're a plaintiff's lawyer, can I just have a show of hands? Everybody here a plaintiff's lawyer? There are very few tax lawyers in the room, I think. So if you want to know a few things about tax and want to be sensitive to Section 104 issues, if you go to my website, which is woodllp.com, there's a search. If you go to articles, which is one of the tabs I think on the website, and there's a search window. You can type in, sex abuse, or and you will. I assure you, will not get any pictures. What you will get is tax articles about sex abuse. If you type in structuring attorney's fees, you'll get articles. I know Margie has reprinted one short one in here that I think was from the LA Daily Journal that's about structuring attorney's fees. You'll get, there's 6 or 8 or 10 articles on attorney's fees. But the scope of Section 104, the tax treatment of personal physical injury awards, that's a huge area for me. I see lots of cases every year, lots of gray areas. What about PTSD? What about wrongful imprisonment? These kinds of things. And as you might expect, the facts are really important, but also the documents are important. And what you say in a settlement agreement is really important. What you want with your tax return is to file it and have it sail through fine, and that's what every plaintiff should want as well. And we had, at the noon session today, somebody asked a question about, well, gosh, how does anybody know, how does the IRS know about any of this stuff? Which is a good question, and the answer is it's not one thing. Maybe because of the nature of what I do, I see a large volume of cases every year in which the IRS has read jury verdicts, or the IRS has read the newspaper, or they've looked online and they see your website or the Daily News reporting about a case. So they find out about cases, and they find out about plaintiffs, and they find out about successful lawyers. That doesn't mean you shouldn't do press. It just means it's part of life. Another big way is, of course, 1099s. Probably a bigger way, really. And you should always be thinking about how the tax reporting is going to be done. And if you can, and you may not want to be doing this yourself, but if you can, get some tax input from somebody before the documents are signed. I know one of our big topics tonight is tax treatment of attorney's fee structures for all of you. How do you do it? When do you do it? And if you're doing those things, it's very frequently at the same time you're doing some planning for the client and the client's recovery. Let me go to John.
Rob brought up a good issue. There's kind of a changing trend with defendants. They're starting to actually do what they've been supposed to be doing all these years. They're tax reporting. There's a code section that requires them to do reporting of settlements that are taxable, 6041. You know, why is this a big deal? There are a lot of gray area cases, and when it comes to your clients, there's a giant difference between a tax-free case and a taxable case in terms of their net recovery. And the devil's in the details. I've seen cases that should have been tax-free that people ended up losing in tax court. I've seen cases that they missed whole areas, and a lot of it comes down to drafting and documents. But this really goes back, Rob mentioned 1996. They changed the tax code in 96. I get this question a lot from employment lawyers because I tell them, well, the emotional distress, the mental anguish is taxable. Well, when did that happen? It was recent. It was 96. Kurt Cobain was still alive, and there were 3 Beatles then instead of 2. But it's important because these things are popping up on audits more, and the IRS has something called the MSSP, Market Segment Specialization Program. They're targeting defendants. They're checking to see if they're doing their tax reporting. So why is that? How does that affect you with your clients? Our responsibility is to get the best settlement possible for the client. And if there is a way to argue that some of this should be tax-free, then we should look for that. If there's a way to spread out the tax hit through a structured settlement, say it's a wrongful imprisonment case or a defamation case, if you spread it out, you could cut their taxes down significantly. Because when something goes wrong, your clients, the first person they're going to call is you. So back in 96, what was happening, or actually prior to 96, employment lawyers were cleverly reallocating settlements and moving it from wages to emotional distress and mental anguish. Back then, all you needed was a personal injury. Good for them. They found a good loophole. They exploited it. Sort of culminated in a Supreme Court case called Schleier. It was a United Airlines pilot. He was terminated for he was too old. They said, you hit a certain age, you're mandatorily retired. He sued for age discrimination under ADA. Won, tried to claim it as tax-free, didn't pay tax, took it to court. He ultimately lost. And that's where you first saw that glimmer that you needed to have a physical injury to be tax exempt. It used to be you needed 2 things, physical and a tort. In 2012, they said you don't need to have a tort, it just needs to be physical. So when Congress and the IRS imported this physical requirement for tax exemption, they cleverly forgot to tell us what that means. So when you think about it, what is physical? We have a few glimmers here and there. Is physical something you can see? Let's say Rosa in the back who drives with a lead foot. Everybody knows this in town. She crashes. She runs me down in the street, breaks my leg. Clearly observable, clearly tax-free. So whatever Rosa has to pay me is tax exempt under 104A2. But what about something you can't see? We have an employment ruling, came out in 2000. Rob likes to call it the bruise ruling, but it was a sexual harassment case. The ruling number is 2004-1022. For those of you who want to double check to make sure we're not making this up. But she was subject to a series of escalating harassment. She worked for a trucking company. I know this is shocking to think that truck drivers might be sexist, but it happens. And ultimately it culminated in a physical event, a battery, and which left bruises. And the service sort of drew their bright line distinction and said, okay, at the point it's observable, where you can see it, then it's tax-free. Before that, it's taxable. And when you think about that, that's kind of a silly standard. Again, let's say I was in my car when Rosa tried to run me over and I just got whiplash. Well, you can't see soft tissue injuries. You can't even see it with diagnostic equipment. Pulled muscles don't show up on an x-ray. Yet nobody would say that an auto injury recovery is taxable. So is it observable to the naked eye? Is it observable through diagnostic equipment? There's so many holes you can poke into the IRS's thinking with the observable harm standard. You know, so you get into weird things like, you know, molestation. 2 years ago, I appeared in front of Treasury and Service to argue this issue, that say in molestation cases or even, you know, sexual assault, injury, there are a number of medical studies that these are not observable harms. In 56% of the injuries, there's nothing that you could record, nothing observable. Does that make it a non-physical injury? Rob mentioned post-traumatic stress disorder. We are dealing now with a lot of civilian contractors returning from Afghanistan who have post-traumatic stress disorder. There are a number of medical studies that show that the brain chemistry and the neural pathways are irrevocably altered under the stress of combat situations. So it's measurable. Yet anecdotally, we're getting feedback that the service may look at PTSD as taxable if it's a tort. Workers' compensation, if it's a Defense Base Act case, all you need is personal and work comp, so it's a little different there, still tax-free. You know, one that Rob and I go back and forth on a lot is wrongful imprisonment. You've lost your physical freedom, you're restrained, your civil liberties are taken. Is that physical? You know, we've got the service, at least in one case, Stadnick. Is it Ohio? Ohio case. Yeah, she was arrested. The bank thought she was passing bad checks. They took her in. They didn't beat her. They didn't do anything to physically hurt her. They put her in an orange jumpsuit, which I suppose is traumatic, especially if orange is not your color. It took her picture. 8 hours later, she was released. They gave her a settlement. She tried to exclude it from income. The service said no, sent her a deficiency notice. They went to court. She lost. So we have that one case where the service has said, well, the short-term imprisonment is taxable. Contrasting that, yes, sir?
It's okay to ask questions now?
Yeah, absolutely. I do love to hear myself talk, but I'll stop for questions.
You're hitting on something I've been doing for 10 or 15 years, been allocating part to this. But we have clients, a lot of times we have post-traumatic stress, you end up having an observable injury, but it's secondary or incidental. You get rashes, hair loss, hives, sleeplessness is not really observable. I can see somebody dead awake, but I mean, is there a case on that yet?
Well, the really interesting, you hit on an incredibly important subset of this. And when Congress changed the law in '96 to import the physical requirement, physical injury or physical sickness, there was a subcommittee report that accompanied the legislation. And what that subcommittee report said that non-physical injuries include things like physical manifestations. They mentioned things like high blood pressure, migraines, nausea. There was a great case, I think, out of the second, the Murphy decision. The lady had bruxism, which I had no idea what that was. It's where you grind your teeth down from stress. I finally know what I've been causing my wife all these years. It's bruxism. You know, because it's a manifestation of a non-physical injury, it's still under the code taxable.
So a bruise is direct, the rashes and the hives.
If it's a manifestation of something non-physical, it's taxable, and there are a number of tax court cases that have sided with the service on that issue. Now, the interesting thing, even in that, you know, a good tax lawyer like Rob here will, there's always areas of opportunity. You know, when you bring in, you know, a settlement consultant or a financial planner to get in earlier and talk about these things, what I've seen is one of the most overlooked things by attorneys that handle employment cases, PTSD, wrongful imprisonment. There is a giant carve-out for future medical expenses. So I'm a veteran. I know the PTSD area very well. So imagine, if you will, a serviceman or a contractor comes back PTSD. You have enormous future medical expenses. You have prescription drugs, you have mental health counseling, psychiatric care. These are all very expensive, very limited coverage under most health plans. And what the carve-out Congress gave is that even if it's a non-physical injury, as long as you haven't taken a deduction for that medical expense, you can exclude the medical expenses. Now, again, the IRS does us no favor here, and it just says medical expenses. It doesn't say past, it doesn't say future. Most settlements with carriers will include past and future, but they sort of lump it into one big category, expenses. But there, even in what would ordinarily be a taxable settlement, are pockets of tax exemption. But that's why you bring in somebody to take a look at it. As trial lawyers, you don't want to be in that position of trying to parse out taxes. Bring in a settlement consultant like Margie, bring in somebody like Rob, bring in somebody like Ken, let them, you notice I'm volunteering everybody but myself, to help you. And frankly, it gives you a lot of cover. There are, you want your client to get the best recovery, but you can't protect them from themselves. All you can do is make them aware of the options and then let them decide. But this protects you, I think, from any allegations that you didn't get me the settlement or you did something wrong.
One thing I would say too about a case that you were talking about where you've got some kind of allocation is a lot of it comes down to documents, and any of us could debate this question of what's a symptom of emotional distress, which would be taxable. So my hair's falling out because I'm getting old. My hair's falling out because it's a symptom of emotional distress, or is my hair falling out because the doctor says I have, XYZ, some eczema or something, and what gave me eczema? That's a physical sickness, I presume. I got it because of stress or something. So that, in my book, I think would be excludable. So sometimes it depends on how good your documents are. My worry on the PTSD cases, and I feel very strongly that PTSD is in the good category of tax-free, is it's the stuff where people abuse it, where it's not really real, where people are, somebody sort of drove by them once and said, oh yeah, they have PTSD, and they used that word once, and therefore they exclude a couple $1 million. Those cases are going to be just like the wrongful imprisonment where the woman, this nice housewife from Ohio, knew all the cops, I guess, and she was in for 8 hours, and the fatal thing in the tax case where she lost on excluding the wrongful imprisonment recovery was it was 8 hours, and she admitted, to her credit, she said honestly, nobody did anything bad to me. No, nobody roughed me up. Everyone was very polite. It was strictly that she was locked up for 8 hours. But anyway, I think there is still a lot of room, as John says, in employment cases. There's a huge amount of room, and certainly in the cases, if you're doing primarily PI cases, there's still a lot of room left in Section 104. But if it's not plain vanilla auto accident or something, and don't forget, interest and punitives are always taxable. If it's not a plain vanilla case, maybe get some outside help.
What other questions do you all have before we turn to topics that impact you all more directly? Does anybody else have questions that concern taxation of damages? You can always ask them at the end as well, but I just want to allow enough time to talk about the financial stuff for your own sakes. Okay, and we'll come back to any questions at the end. But, another thing that attorneys who do contingency work think about, is my thing still on? It's fine. Okay, is how to ensure solvency from year to year in an industry where income's unpredictable, how to finance cases, how to make a living and invest wisely, and again, like how to have enough liquidity to do what you need to do immediately but still invest for the future. Can you all please speak to the value of structured settlements for the attorneys themselves and the value of the tax-deferred growth that legal fee structures offer attorneys? Taking all the pressures that you do have given the nature of your work, a nice perk that you all have is the ability to defer compensation on your cases and invest pre-tax dollars into fixed income or variable products. That's a benefit that's unique to plaintiffs' attorneys who take contingency cases.
I'll take that.
Long-winded question. Yeah. Ken,
Actually,
I'll
I'm
let
going
you
to
talk.
stand since I can't see half the group. Good afternoon. My name's Ken Stern. Watch this. So tonight I'm going to talk just for a couple minutes about what Margie had alluded to, which is structured settlements. And since I have two tax attorneys over here, I know that I'm backed up. Any of the easy questions, just give it to them. But what I do want to address is we do advanced planning, and litigation is one of our specialties. We do investment management and tax planning. And before I get into the structured settlement itself, I want to make sure that what we see, I mean, the litigation market, it's the best of times, it's the worst of times. I love the ROI. The question, as Margie so accurately alluded to, is can you remain solvent long enough to make that ROI work? The courts are more backed up, the insurance companies are more aggressive, they know how to work it. From what we see, the most successful attorneys are obviously working that and mitigating it. It's not like it was prior to the last iteration, whereas you can take your fees if you have a big year and average over several years. You can't do that. And with the tax bracket as high as it is, and California, I believe now, state and federal with everything else is in a top 5 in terms of combined, number one in terms of taxes.
Yay, California, #1 in taxes.
He's only saying that because he doesn't live here.
To me, and we can do the math however you want, we can compute it in any different iteration, and I love doing all of that. At the end of the day, show me a scenario whereas if you pay the tax up front and take a net number, you can't make more money than if you average it over a period of time. We don't know what we don't know. I have a hard time believing that taxes go higher from here. I have a hard time believing that your tax bracket is higher 15 or 20 years from now, and I don't understand, if you have any compounding whatsoever, how you can't structure it. Yet somewhere, we are not getting the message out there properly. As you all know, there's billions and billions and billions of dollars in cases that are settled on a yearly basis, and perhaps 4 or, John, do you know, 5 billion is actually structured? 5 billion in structure. I mean, we do more hard money lending to our clients at, it's not usury rates because it's a advance. No, it's clearly usury, but you can't call it a loan because or you can't call it an interest rate because it's a loan against a future receivable. So you get around the usury laws. But the fact of the matter is that it's a no-brainer. You have to look at structuring. So the question is what does it mean? I'm going to let the tax gentleman talk about how you structure it, what needs to be in your structured language, what constructive receipt is, how you get it in so that it is a more or less just a administrative clause within your structured settlement. But at the end of the day, whether it's your client and you protecting yourself because you know if they're going to need the money now, they're going to need it a year from now, they're going to need it 5 years from now, structuring for the client is a no-brainer. You're doing a good thing for them. And doing it for you. If you look at the math and you open up the menu of what Margie, Kyle, and Millennium, and all these other individuals have structured, it is so compelling. Whereas you could say, all right, well, I want to take my fee, I want to put it in a qualified settlement fund, and I want to pay it out over X number of years. No problem. Or you could say, you know what, better yet, show me a scenario where a bank will give me 100 cents on my dollar and give me a low enough interest rate, like a 3% mortgage today. Can I work the spread on that? Probably. So you get 100% of your money, but you don't pay taxes on it. You pay it structured over as many years as you structure the settlement.
Hey, Ken, can I just, I don't know if this observation helps, but I've been a tax lawyer for 34 years now. And I mean, a very fundamental basic principle of tax planning is that you try to accelerate deductions and you try to defer income. You don't want to pay tax now if you can pay tax later. And so, I mean, California is the land of the 1031 exchange traditionally, 20, 30 years ago. People are still doing it. Why? Because you want to keep rolling the gain, the real estate gain. As it goes up, you want to keep reinvesting the money. It's really the same principle. I think what Ken's saying is if you look at the numbers and you're really comparing apples to apples, paying tax later is always better. Right.
Almost always. And the 1031 even better because you can just keep exchanging it until you die. Right. Well, it's not better for you, but better.
Really smart.
Really smart, right. It's better for your heirs because the stepped up basis. But I mean, even to the point where I was talking about how you structure it, you want to make sure that you're doing the right thing for your clients and you're avoiding risk. pick your option. You want to do completion insurance? You want to buy zero coupon bonds? You want to do that to know that you guarantee 100 cents on the dollar and take the difference and do long-term options on an index like the S&P? Do it. You want to take a fee structured plus kind of a program that Kyle and Margie and Millennium has structured? Invest it in the markets. That's the power of how you structure your earnings. And obviously, I'm not talking today about your personal finance, and I don't think we would be getting the credits for it, but you should be looking into it. Most of the attorneys that I work with, whether they're their own offices or they're in a larger organization, it's unbelievable how little is being taken advantage of. To Rob's point in regards to tax deferral, no defined benefit plans are in place. No variable types of defined benefit like a profit sharing plan where you really have the option of dialing up or dialing down what you're doing. Not really looking at the expenses and making sure that if you are audited, you have the defenses in place to defend that audit and taking advantage of the deductions that you get on your expenses. So that's what I wanted to talk a little bit about QFSFs, because clearly there's a disconnect between the number of settlements and what is being realized and how many QSFs are being structured. So I think we can talk about that if there are questions, or how it's structured, or what language needs to go into the documents.
Just to sort of circle around what Ken said, that anybody working on a contingency fee basis, physical injury, employment, I think some states even divorce, contract, as long as it's contingency based, trial lawyers have a unique opportunity. There are a mountain of deferred compensation rules that you have to abide by surrounding timing and risk of forfeiture. And in the middle of this is this exception for trial lawyers. You don't have to take it at 59.5. You don't have minimum distributions. You don't have maximum contributions. You can structure anything you want. You can structure 10% of your fee. You can structure 80%, 100%. You can pay it out over your life. You can defer it for 20 years. Literally whatever you can imagine. So as you can imagine, there's a lot of functional benefits. You know, your income as trial lawyers does this. It's up and down and up and down. You don't know when the next case is going to settle. It's a chance to level out your income. But I guess when I talk to trial lawyers about fee structures, I put it just this simply. Look, Uncle Sam's going to take 40%. State of California is going to take between 9.3 and 11.3. Oh, and by the way, welcome. 13.3. And welcome to new code section 1411, which imposes a 3.8% tax on your net investment income if you earn over $250,000, plus your SECA tax. So you know, you're not anywhere close to. You know, so you're going to lose a giant chunk of money. Why not put that to work for you? You know, and that's where you have to. You know, I don't do numbers. I call Ken or I call Margie. But you know, that's where you have to look, you know, have sort of this team approach and say, okay, if this makes sense, you know, does it make sense for a short-term deferral just to spread out your tax hit? Does it make sense for a long-term plan for yourself personally? Does it make sense to tie it into firm overhead, you know, to cover expenses and future trials? Do you want to do this for some of the junior partners to tie them to the firm? You know, you don't want your drizzle makers running off and starting their own firms. You want to sort of keep them there. But there's a lot of protections. There's bankruptcy and creditor protection. So it's got a lot of aspects beyond just the tax. But the thing that always struck me, and this is something I helped write back in 2003, was attorneys are exempted from a lot of the deferred comp rules. So it's a unique opportunity. And Ken mentioned this earlier, it's really kind of shocking how few attorneys take advantage of this. And I think sometimes they think maybe it's an all or nothing. I have to structure my fee or I don't. And you don't. It's infinitely malleable until the point you or your client sign the settlement agreement.
And even then.
And even then, a good tax lawyer can find you an exception. But I think that segues into, you know, timing and constructive receipt.
That's what I was going to get to as well. Just some of the preemptive planning that needs to occur to make a fee structure possible.
Don't take the money into your trust account. I mean, we were kind of joking about this a few hours ago. I mean, you don't want to have the money, have your big payday, and I think you all know this, and have it sitting in your trust account, and then call up Margie or someone else and say, gosh, I'm thinking about structuring, or my client wants to structure. For your client or for you, it's too late at that point. There are, in some limited cases, there are sometimes you can put the genie back in the bottle, but it's not something you can try at home, and it's a lot more expensive than if you do it the right way. So I think we were joking earlier today about calling Ken at 9 o'clock on Sunday night, and so you may get a lot of these calls. Because you got a mediation Monday or something, try to do it a little bit more with a little more notice than that, but plan ahead. Don't sign documents. You do have some formal requirements, whether it's the client structuring or you structuring a portion of your fee or both. So plan a week ahead of time or more than that. It's a good time, I find, a good time to start thinking about tax issues and planning issues is when the case is getting close to settlement. Well, how do you know? You might not know at all, but if you are going to mediate a month from now, it's a good time to make a couple free phone calls and say, look, I don't know, the case might come in, might be $500,000, might be $5 million, I don't really know, here's why. Are there any tax issues here? Is there anything I need to do to structure it? And make those calls now. Yeah.
I'm a mediator, and I mediate a lot of injury cases. And there is some reticence to executing settlement agreements at mediation. The pro, of course, is you've got a enforceable agreement. The con is this issue that you're addressing. Can you address me and the audience regarding the issue of executing settlement agreements at mediation, whether those are dispositive of tax consequences or not, and if so, what language needs to appear in those agreements to maximize tax benefits?
Boy, well stated, and a terribly important point. I wish I had a perfect answer for you. I've certainly seen the issue, just so everyone hears it. It's from the mediator, a mediator up here, and the question of, the push and pull, should there be a document executed at the mediation. I think most people think, and I'm one of them, that you got to have something signed before everybody leaves the room. If there's a handshake deal, you don't want it to evaporate overnight, and that happens frequently. At the same time, as a tax lawyer, if I have been consulted before the mediation and have some input, or I'm on call on Sunday night at 9 o'clock or whenever it is, on my cell phone, it may be that there's something that can be done and it can be disposed of and done. However, I find there are two possible answers on what to sign. One is a term sheet three possible answers. One is a term sheet that says that we're all agreeing it's settled for X dollars and we're going to work on a comprehensive settlement agreement, period. Everybody signs it. It's not specific as to is it binding or not. Or it says we're all going to work on a comprehensive settlement agreement, and if we don't produce a comprehensive settlement agreement we can all sign, then this is it. This is binding. And you all have seen those. I'm sure you have. The mediator uses these, I expect. Or it says the reverse of that, which is we're all signing this, and if we don't agree on a comprehensive agreement, then, of course, we don't have an agreement. I've had cases where I've been brought in where there's a fight, people are trying to sue each other, and I get brought in. I don't like doing this, but I've done it, as sort of the tax person for the mediation to represent everybody, to come to the mediator and says, look, the way that the taxes ought to be solved is this. Usually it's easier for me, for obvious reasons, to be more sort of compartmentalized, represent only one person. I don't think there's a right way to do it. I think the best thing is if you really want to have the case done, and you have sometimes people sitting with their laptops doing a binding settlement agreement, and so there is no term sheet. So it's a full binding settlement agreement, and you just stay up late and try to get it done. In those, obviously, then you can hammer out all the tax details if you have tax knowledge. I've seen carve-outs done where you have one of the variations I described, some kind of a term sheet, but it says we all agree it's X dollars, we all agree we're going to work on a settlement agreement. It may be, I would think the defense or the mediator may say, look, we got to have something that says this is binding if, and so we want something. So maybe there's an accommodation provision, provided that everyone's going to cooperate on tax language or something like that. There's no perfect solution. And I don't know, sir, if you want to speak a little more on this.
My process is to have the defendant draft the settlement agreement and send it to the plaintiff's counsel in advance of the mediation for review and comment. Hopefully that comment is received and a revision is made, but that doesn't resolve the issue we're talking about, which is the case is now resolved for $100,000, and the agreement cites that it's $100,000 in cash and or annuities. Perhaps that's all that it says, signed by the parties. It's a 6-page agreement. It's binding and enforceable. There's no question about that. What have we now done to the tax consequences is my question.
Yeah, well, and I mean, the question there, and you're importing some or trying to import some flexibility, saying cash or annuities. But I think my tax lawyer answer to that, which is unfortunately the careful answer, is that it's too late to structure, because you don't. The traditional constructive receipt is you have the right to get cash, and therefore if you say I don't want cash, pay me tomorrow, it's too late. I don't know, John, if you want to comment what your company, for example, does with that.
Yeah,
and do you structure it or not?
Yeah, it's the slippery slope, because what you don't want that agreement to appear to do is to convey a lump sum that the plaintiff has the option unilaterally to structure or not structure. That's a textbook constructive receipt problem. There's a fine line to walk. I think what's instructive is there was a Rev Proc or Rev ruling in 2003 115. And it sort of tells us sort of the right and wrong way to do those situations. You can know what the cost is. And you can elect to structure some portion of that. How you phrase it is critical. And I think the settlement agreement has to be clear that ideally it would be X in cash, X to be paid out in a structured settlement, see Exhibit A, and the parties work that out. Afterwards, you've got to preserve the tax treatment, but I think you have to look at it sort of in reverse. Is there anything in this document that would convey to the IRS that this was a lump sum settlement that was sort of backdoored into a structure? We're very careful with mediation agreements. We're extremely careful in another area that's a pitfall related to this, are high-low and binding arbitrations. So that stuff has to, I think you're sort of ahead of the power curve on this. These issues have to be addressed in advance of the negotiations or the arbitration. I think if you lay the groundwork to preserve the ability to structure, and I would put some restrictions on it that are binding on the plaintiff, that this has got to be agreeable to the defense, it's got to be executed in X number of days. You don't, again, do you want to avoid even the appearance that this plaintiff took the cash and then, I want to structure now?
Yeah, I agree with what John says, and I think you're doing, to me, I think you're doing a great service for all the lawyers and the clients involved by actually trying to push them to, and I presume you have good results in mediation, to try to push everybody to sort of get together and start thinking about this stuff, so that it's not at 9 or 10 o'clock at night when everyone finally comes to a number and then, okay, now what? Because then it's very easy to screw it up. One thing, and this is more aggressive than some people would like, but if to some extent and I guess this is, it's sort of self-proving, but okay, so you got this document. Let's say it's signed. Let's say I even say, well, gosh, looks like constructive receipt to me. But a week later, everybody has come together. Everybody agrees, well, we're superseding that crappy thing we did at that night, and it's as if it didn't exist. We're now tearing it up and doing a new one, metaphorically tearing it up. And I think that sort of stuff gets done. And I think the IRS often looks the other way, if they ever see it. I don't know, John?
I think you're right.
I mean, what we're seeing a lot of is why not just default to the QSF? If it's a group settlement, let's say, why not default to the QSF? Make sure that you then go ahead and understand all of the individual people that are in the group, decide if they want to structure or not. And if they don't want to structure and the attorney doesn't think there's going to be any further litigation for fees or whatnot, disperse the money at that time.
Can I just say, for anybody not know what a qualified settlement fund is? Okay, good. Okay, so.
We have one honest person.
Okay, yeah, thank you. I was afraid no one was going to raise it. So a qualified settlement fund, and Ken's right, but a qualified settlement fund is, and if you want like a 1 or 2 page treatment of what it is, go to my website, woodllp.com, and type in qualified settlement fund in the search window, and you'll get a few articles. And I mean, they're real simple. It's a court-approved, any judge can do it, a court-approved fund where basically the defendant pays the money and the defendant gets a complete release, and it's a tax-neutral thing while it sits there, and it holds the money. I know I'm being somewhat cryptic, but it holds the money, and then you get time, and you have time to worry about, does the client want to structure, clients want to structure, do the lawyers want to structure, and it's a tax-neutral entity that holds the money after the defendants. They started in class actions. That's where they were very, very big. Now they're used in a lot of other cases as well.
You can almost think of it, it's maybe analogous to a 1031 exchange where you have an accommodator. If you can't find your property, no harm, no foul, and it comes back.
I just wanted to touch on one topic before we run out of time. The impact of whether you take your fees in cash or a structure can have a major impact on your clients. So there's really, when you think about fees, there's really 3 big buckets. There's contingency fees on tax-free cases like physical injury, workers' compensation. Has no impact to your client whether you structure or not, because they don't pay tax on what you receive. Whether you structure or not is really determined by what's in your best financial interest. You have taxable employment cases, and then taxable non-employment cases. And by non-employment, I mean punitive damages, defamation, anything other than employment. So you think employment, ADA, ADEA, state employment law, whistleblower. So when you settle a taxable case, you and your client will get a 1099, or your client may get a W-2 if it's wages in an employment case. They're taxed on the gross amount. If it's an employment case, they get what's called an above-the-line deduction. What it means effectively is they only pay tax on what they get. So they don't recognize, any tax liability for what counsel gets. That makes sense. The dangerous part is for those of you that run into cases, say punitive damage, not an uncommon situation, defamation, breach of contract, slander, anything taxable non-employment. Your client is taxed on the gross amount and then gets what they call a miscellaneous itemized deduction. It's what they call below the line. And why that's important is if your client gets too much money, or if too much money is recognized in income, they'll lose that deduction under the alternative minimum tax rules. And I would put everybody to sleep in 5 minutes if we try to talk about AMT. But the important, okay, I'll make it quick.
You mentioned AMT, and there was this great bolt out of the sky.
That's a sign.
He's blaspheming against AMT again.
But let me give you an extreme case that happened in Chicago about 10 years ago. There's a lady called Cynthia Spina. If you go to CBS News, Eye on America, do a search, Spina. This was on the front page of the Chicago Tribune, Wall Street Journal, New York Times, CBS News. She had a case. It was an employment case. At the time, employment didn't have the special carve-out. It was a taxable case. $3 million after a lengthy trial. Appeal, reduced on appeal to $1.3 million. So as you all know, trials are expensive, appeals are expensive, quite a few, a lot of expense. She netted $300,000, so a very expensive trial and appeal. She then got a notice from the IRS that she owed $400,000 in taxes on her $300,000 recovery. Why is that? Because she owed tax on the gross settlement of 1.3, and under AMT, her deduction for the attorney fees were disallowed. So imagine what that will do to your practices if all of a sudden people would be better off financially with a defense verdict. So they fixed that for employment cases in 2004 under the Civil Rights Fairness provision of the Jobs Act. So if it's one of the, and Rob actually knows these by heart, I don't, but there's about 24 enumerated exceptions under the employment laws, and one sort of kitchen sink provision or other violation of employment law. But if it's not, if it, again, punitive damages, defamation, breach of contract, things of that nature, you know, that's when you want to bring in a Ken, a Margie, a Rob to maybe look at this and say, okay, we roughly know what we're going to get in settlement. Let's start thinking about the best way to structure this settlement, because the last thing you want to do is have your client walk away with pennies on the dollar.
Yeah, and just to be clear on when John is talking about these attorney's fee issues, so it may be that you're only a personal physical injury lawyer and you do only, you know, serious injury cases. And so you might think, well, gosh, if all, I mean, I'm not doing employment cases, I'm not doing contract cases, only personal physical injury, and this is a wrongful death case. You've got one, you know, and the case goes to verdict and is on appeal and then settles. And let's say you've got $1 million of compensatory damages for the wrongful death and $10 million of punitives. The attorney's fees that you get have to be allocated, and the presumptive rule is pro rata between the between those two, between, you know, 1/10 or 1/11 tax-free and the rest of it taxable, and that means the attorney's fees are going to be non-deductible within the rule that John just talked about. So it really sneaks up on people in ways that are surprising.
I think a lot of this has been missed, but the service is tracking, they're cracking down on this. When you look at their, if you have insomnia, read their market segment specialization program. They're looking through courthouse records, they're looking at newspaper articles, they're enforcing the reporting obligations on defendants and insurers, which they never did before. So they're starting to catch these. The nice thing is there is a fix for this, but you want to do it in advance. Whether you do a qualified settlement fund or you do a structure directly with the insurer or defendant, you have to have defense cooperation for these. The nice thing is the structures have been around for 30 some odd years. You know, most insurance companies and self-insureds know about structures. They're easy to get, but you have to ask for them. You have to do a little bit of advanced planning. And again, I like bringing in, you know, these folks because you don't want to mess with tax issues. You don't want to mess with settlement issues when it comes to structures. You know, take that burden off of yourself. You know, give yourself some protection. At least disclose to the client and let them decide whether they want to do this or not. But I think,
John, I do just want to say that we are at time in case anybody needs to go, but I do want to allow some time for questions if you all have them. There's a lot we didn't cover that I was planning to, so if there was something you're looking forward to hearing, we've not gotten to it, please just ask. Yeah, and I'll get you time.
love that case.
Yeah, I have an answer, but why don't you go ahead?
There's sort of a bright line distinction, and it all stems from the time we got rid of him in Chicago, but Rodman, I think, came somewhere out here to play basketball, but it was during
North Korea most recently,
yeah,
Dennis Rodman.
but he didn't kick anybody there. But you know, during a Lakers game, Dennis Rodman decides he's going to, you know, kick a cameraman in the groin with his size 13s. Boy, that's a physical injury if I ever saw it. It's on TV. It's recorded for posterity. The cameraman's name was Amos. They settled. He understandably said, I'm not going to pay tax on this. It's physical injury 104A2. Lo and behold, the IRS sends a deficiency notice. You owe us tax. And what happened is the majority of that settlement was not for physical injury. The majority of that settlement, as you read the settlement agreement, was specifically for him to not talk to the press, not cooperate with the prosecution, not run around selling his story to TMZ. Very little of that money represented actual compensation for the physical injury. So really your bright line is where you have a confidentiality agreement, and it's sort of the boilerplate standard ones you see in most injury settlement agreements. It's a boilerplate. It doesn't trigger taxation. But if you're specifically paying them money to be quiet, that's a taxable event under analysis of Amos. But your boilerplates, I wouldn't worry about.
Yeah, I think what happened as a result of that Amos case that John described is a lot of people, I think, overreacted and started saying, oh my God, all this stuff now, if we put in confidentiality, it's taxable. But unless you put a specific dollar amount or something, which has, you know, a lot of reasons that you might not want to do that, just stick your boilerplate confidentiality in as you always did and don't worry about it.
Who says tax law is not exciting? Dennis Rodman, physical injuries, kicking, North Korea. It's exciting stuff.
Todd, you had a question? Or were you just gesturing?
What? That hurts, sir. That hurts.
Class action context, the timing of the taxable event to transfer the money from the defendant to somebody's trust account. And further to that question, when you have a class action case with multiple plaintiffs' attorneys dividing a specified amount of money, inevitably there's always disputes. Is there a provision where you could hold the money in escrow pending the resolution of the dispute, or is it transfer the money to some kind of escrow account?
Or instead of escrow, why not qualified settlement fund?
Well, that's my question, you know, if one of the 5 attorneys would like to establish a qualified settlement structured fund, the other 4 want to take the money and spend it like I would. When the defendant is going to pay the fee, they want the plaintiffs to sort out the money on their own, right? So in the pendency of that dispute, is that a taxable event? How does that occur, and how do you avoid that from happening? Because it's an infrequent case where you have a class action and only one firm is receiving the fee.
Right. Well, I mean, my answer would be, and I guess I've seen lots of variations, and you know, tax lawyers are like everybody else, used to working with what you get. However, you don't want to do that, and somebody is going to end up tagged with income if the lawyer who's acting as the main lawyer in the case gets the money in his or her trust account, even though there's an obligation to send the money on to 4 or 5 other lawyers, and there may be disputes. It's a very bad thing. So you want to plan ahead. Absolutely, it's fine to have it pre-wired so that, and as Ken said, the Qualified Settlement Fund works well in that context, especially if there are disputes. So set that up. You know, allow yourself a few days, a week, if possible, to set it up. That's easy to do. You don't want, though, to have money sitting in your trust account, because the undisputed part, at least, would be taxable. And that's pretty black letter, and I've seen people get in that box where they say, well, wait a minute, clearly it's not income because we still got a dispute. Well, how much is your dispute? $8. How much is the money? $10 million. Well, obviously, you can't have a tiny little dispute. I mean, the IRS isn't that stupid.
I mean, the easy answer, I think, to Ken's point is if it's in a qualified settlement fund, you know when the money's going to be paid, set the QS up in advance. The nice thing is, you know, if you've got 4 attorneys who want cash and one wants to structure, fine. QSF can distribute the fees in cash the next day. Yeah. So it's a nice parking mechanism. Absent the QSF, you know, your court order approving distribution of attorney fees. I've done a couple of those that way, where the order itself has that, you know, counsel is entitled to $10 million fees, or, you know, if we structure it, you know, counsel is entitled to $1 million per year for 10 years. You know, that's always a fun discussion, explaining to the judge why the lawyers should get more money. They like those, but they're done. We've done them before. My preference is the QSF because it gives you time, and it doesn't bind the other lawyers to structuring. You know, it's flexibility and freedom.
And you've got if you have the QSF, the Qualified Settlement Fund, you've got the defendant, you know, the defendant or plural defendants out of the picture, so that, you know, you have that element gone too.
If you have a mediation, you want to structure the money both for the client and for the attorney. Do you need, the defense usually shows up with their own structured settlement people. So do we need to call Margie up to have her come in? with us?
It's like celebrity deathmatch, the structure people fight in.
The nice thing about settlement consultants, I don't use the word broker, I think it's a little bit of a misnomer, is it's more of a consulting. That's funny, that's funny. He'll be here all week. It's, you don't pay for their services, defense doesn't pay for their services, so why not bring in your own consultant? I mean, would you, if the defense sends you an IME, would you just, you know what, that's fine, I'm going to base my damage calculation on that. And they work cooperatively, and frankly, I think that's the best of all worlds.
I mean, there are a lot of iterations, right? I mean, if you're trying to use different rates, or somebody wants only Treasury, or somebody wants something different than Treasury, or someone is older and wants a shorter annuity cycle, someone wants a longer. So you really do have, I think, many different variations and iterations to go through, so why not have both sides represented?
And Bob, I appreciate that question. On more cases than not, there is a broker and I use the word broker because I think it gives me a nice kind of hard edge that as a woman doesn't come as naturally. So I like to say I'm a structured settlement broker instead of the softer consultant, but I take and appreciate your point. It's just semantics. On more cases than not, there is a broker representing both sides, and that actually, even though we end up splitting commission, which isn't such a rosy thing, it can often help a structure happen that wouldn't happen otherwise, because we do need defense cooperation to fund a structure either for a client or for the attorney. So we end up working together the same way that, like you were using the real estate analogy, it works out the same way. Thanks for that question. Yeah, Tom.
I'll tell you, this has been a real eye-opener. Thank you very much.
Oh, good, thanks.
And really, one of the amazing things is I didn't know Scott's market actually settled cases. I thought they were much bigger.
Thank you. Other questions? Yes, Ginger. And also, Ginger Sussman is the president of a Medicare set-aside and lien resolution company, and we partner with them. If you guys have any questions about Medicare set-asides or lien resolution, Ginger is an attorney herself. She's on top of the latest case law, and she's in constant contact with Center for Medicare Services, if that's what that acronym stands for, and with the lien holders. So she's a valuable resource to have, and I neglected to introduce you at the beginning, but carry on with your question. Thanks. I think 5,000 is the threshold, and Rosa, who manages cases and knows the technicalities even more than I do sometimes, is that right? That we can structure down to 500,000 with MetLife? And we see that, especially on minors cases.
I think, by the way, I mean, if the stacking or whatever you call it, I think that in many ways those are the smartest people. That is the lawyers that say, you know what, little case, big case, case today, case tomorrow, whatever it is, I'm going to start structuring a piece of each case. Because it's a discipline, and it isn't, I think John said black and white, it isn't black and white, you do all or nothing, but it's a good discipline to put something away for a rainy day.
Other questions? Okay. You all, thank you so much for attending. I know that everybody works hard, and thanks for coming. Thank you.